Chapter 5. Forks in the Law. Competing Interpretations of Case Law. A now famous law school classmate once aptly described the experience of reading your first judicial opinion as a lot like stirring cement with your eyelashes. And for most students, it only gets worse when you go to class, where the professor can ask you virtually anything about the case, and for every question there seem to be a dozen different and equally plausible answers. Believe it or not, the law exam may be just the compass you need to help you negotiate this challenging terrain. For when it comes to testing your understanding of the cases you've studied, an exam problem typically asks only one question and expects only one answer. The question is, should you follow the case? And the answer, you guessed it, is maybe. Actually, that's two answers, but more on that in a moment. The typical exam question involves a scenario that is a variation. It may be a slight variation, or it may be a dramatic one on the facts of a case you've studied in class. The parties may be arguing over the capture of oil deposits rather than wild animals, for example, or about the regulation of the internet rather than broadcast television. The scenario thus presents you with another instance of what we've been calling a fork in the law. If you follow the earlier decision, the precedent, you'll reach one result. But if you don't follow the precedent, if instead you distinguish it, your analysis may come out the other way. E.g., the oil deposits case may lead to one result if we follow the rule of Pearson v. Post, and to another if we distinguish that case. Just as the forks in the law we studied in the last chapter depend on how you interpret a statute, the choice between following and distinguishing a precedent depends on how you interpret the earlier case. And in the same way that statutory ambiguities appear in patterns, you can study and learn to recognize plain meaning vs. purposes, competing purposes, etc. There are recurring patterns of ambiguity in case law as well. After a few more words about following and distinguishing cases, we'll devote the rest of the chapter to exploring those patterns. A. Desperately seeking similarity. When to follow precedent. Let's say your constitutional law teacher asks you to evaluate an imaginary statute that outlaws human cloning. The challenge may be brought by an infantile person who seeks to clone himself. Not as far-fetched a scenario as it was when we used this problem a short while ago on an exam. You have read every case for the course 6 times, and you're sure you have never read anything about cloning. So your first reaction is, this isn't fair. I studied so hard, and she asks me about something we never learned. As usual, however, you know more than you think. Odds are very good that you have read Planned Parenthood v. Casey, 505 U.S. 833 1992, the Supreme Court case reaffirming a woman's constitutional right to choose, prior to the viability of the fetus, whether to carry a pregnancy to term. Suppose that instead of viewing the case in the narrow terms of abortion rights, you were to describe Casey more broadly as guaranteeing a right to control one's own reproduction. This kind of broadening is a common lawyer's tactic and pervades public commenter about court cases. Now you have an argument that your course included a case about cloning, even though you didn't see it that way at first. You can challenge the anti-cloning statute on the ground that Casey protects reproductive freedom, and your client is being denied the freedom to reproduce himself. This challenge will generate a debate over the meaning of Casey, just as our discussion of statutes involved a whole set of debates over the meaning of statutory provisions. There are 2 things to notice about this debate. First, it is easy to see how a vigorous and interesting controversy about Casey could occur before a court even got to the question of cloning. So, to use our terminology, there is a fork in the law about what Casey protects abortion rights vs. reproductive freedom that, in theory, could be answered without regard to whether cloning then fits under the category of reproductive freedom. Once categorization becomes the issue, the government might contend, for example, that reproductive freedom should include in vitro fertilization, but not cloning, since the former involves 2 sets of DNA and thus resembles natural conception, whereas the latter does not. The categorization issue, as you might have gathered, involves a fork in the facts, a topic to which we will return in the next chapter. Second, The debate over the meaning of Casey is emblematic of perhaps the most common pattern of ambiguity in case law. What varies in the different ways of looking at Casey is the level of generality at which the holding is stated. The low level of generality makes the case sound as though it's only about abortion. The higher level of generality looks to reproductive freedom. We'll have more to say about this pattern and several others to watch for in a moment. B. Searching for distinctions that make a difference. Some exam questions force students to struggle to find the analogy between a case they have read and the fact pattern the exam presents. Many students, for example, may simply miss the similarity between abortion, the case they know, and cloning, the exam issue. But students who spot the similarity right away face an equally grave danger. For it is just as much a mistake to zero in on similarities and forget to explore the differences. And where the similarities are hard to see comparing cloning to abortion, the differences should stick out like a sore thumb. Indeed, one more clue to finding Waldo is to remember that your professors are trying to build variations on cases you already know. So there will almost always be similarities and differences. If you can spot one easily, look for the other. Most of the time, it will be hiding there somewhere. When it's the differences you are focused on, remember that mere identification is good. But what will really move you to the head of the class is explaining why those differences should matter, why they are significant enough to justify a result different from the one reached in the precedent. Consider, for example, the following problem, taken from a real exam. A visiting scholar is renting a house for a year and hoping to renew the lease in May. The house's owner, however, has the house on the market in December. The owner tells the scholar he can renew only if the house isn't sold by May. The scholar's time in the house has alerted him to certain defects: basement flooding after big rains, loud parties every Thursday night in the house across the street, sparking from the electrical outlets. He decides, however, to tell neither his landlord nor prospective buyers about these defects, because he hopes that last-minute discovery will spoil a deal and give him a chance to renew. What happens instead is that the defects aren't discovered until after the closing, when new owners move in. The new owners are furious and bring suit, not only against the sellers who knew nothing of the defects, but also against the scholar who was present and silent when the house inspections took place. The question asks for an evaluation of the scholar's liability. Most property students are familiar with cases establishing that sellers have an obligation to disclose certain defects to buyers prior to a sale. Yet our question involves the disclosure obligations of a tenant, not a seller. Students who notice this distinction will clearly be on the road to a good answer. But there is further to go. It's never enough merely to notice that some fact, or facts within your exam question, make it different from the case or cases you have read. You have to explain why the legal system should take special note of the different facts. Professors will be very unhappy with answers that conclude the tenant is liable because there is a duty to disclose. Here you miss the different facts altogether. But professors will also be unhappy with answers that say merely, the scholar is not liable because he is not a seller. The scholar presumably also has a different last name from the party found liable in the case you studied. Yet you know intuitively no one cares about that. So, why does it matter so much that we are talking about a tenant and not a seller? Answer that, and you are on the road to an A. C. Patterns of ambiguity to watch for. The case says so. The easiest way to be sure that you need to pause and discuss a fact in your exam that differs from the facts in the case you've read is that the case will tell you. For example, in the case related to our visiting scholar example, the judges might say in clear language, "We hold that the seller of a home is liable for failing to disclose hidden defects." Your professors will delight in writing exam questions that feature someone like a seller, a tenant with a financial interest in the sale, but who is not a seller, to force you to discuss whether the case should apply or be extended to cover the new situation. Rule vs. rationale. We're sure you've noticed that our fact pattern about the visiting scholar strains a bit to construct a financial interest on the scholar's part in hiding the defects from the buyer. Such contortions are often found in exams for a simple reason. The professor is trying to contrast what may be a narrow formulation of the rule in the case, seller liability, with what may be a broader rationale suggested by the case's logic. If the case that imposes liability on sellers does so on the ground that it's not fair for one party to gain financially from hiding information from another, then the rationale may suggest finding the visiting scholar liable, even though the rule itself doesn't cover tenant liability. Indeed, concentrating on the rationale for a case holding is precisely the way to tell whether the facts in your exam question differ from the facts of cases you already know in ways that are relevant to your answer. The visiting scholar example reflects, perhaps, the most familiar contrast between a rule formulated narrowly to cover the facts of the case sellers and a rationale formulated broadly based on underlying principles prevent gain from silence. Here, the exam facts are not covered by the rule, but are arguably covered by the rationale. But it's just as easy to write questions the other way around, where the facts are covered by the rule, but not the rationale. For example, case law in a jurisdiction may establish rules that landlords must provide heat to every room in an apartment or violate the warranty of habitability. The cases may also preclude tenants from waiving the warranty obligations. Suppose your exam question has a rich, well-educated tenant who rents a large, luxury apartment. The landlord informs the tenant that heat in 2 of the rooms is broken and is unlikely to be repaired. Tenant signs a lease acknowledging the problem and explaining that he will use those rooms for computer equipment that does not need heat. The tenant moves in and begins withholding rent on the ground that the landlord is in breach of warranty. Technically, the tenant can rely on the cases. The landlord, however, may argue that the reasons for the rules are to protect poor tenants from waiving their right to the basics, and this tenant is taking advantage. Once again, a court will have to choose between rule and rationale. But in contrast to our visiting scholar hypo, this time, it is the rule that applies tenants can't waive the warranty of habitability, and the rationale that does not. This tenant doesn't need that kind of protection. Levels of generality. Narrow vs. broad holdings. Another way to describe the difference between the rule of a case and its rationale is to describe one of the two as a narrow holding and the other as a broad holding. The technique here parallels the one we encountered in contrasting broad and narrow interpretations of statutes, and there is virtually no limit to how narrow or broad a good waiver can go. We saw it again when we discussed the application of Casey to human cloning. A narrow holding would focus on abortion and have no apparent application to cloning, whereas a broader holding that emphasized reproductive freedom might come out the other way. Let's continue with our visiting scholar example and examine the various ways in which we might describe the holdings of the precedent case. An extremely narrow holding might limit liability to situations where the facts precisely parallel the precedent. Sellers of residential property who don't disclose known defects. Since our visiting scholar is not a seller, he would be home free under this holding. A broader holding focuses somewhat less on the facts of the precedent case and more on its rationale. We impose disclosure liability on sellers not because they are sellers, but because they have a financial interest in the transaction, and it's not fair to permit persons with such an interest to benefit from hiding material information from other parties. This broader holding might lead to liability for the visiting scholar because of his obvious interest in the transaction. On the other hand, since his interest is less financial than it is personal, he likes the place and wants to avoid the hassle of moving. Perhaps even this broader holding would not apply to him. An extremely broad holding, that is, a holding that pays virtually no attention to the particular facts of the precedent case and focuses exclusively on underlying rationales or principles, might require disclosure of known defects in any situation where good faith demands it. Under this holding, liability for the tenant who keeps his own counsel in the hope that the defects will tube the deal between seller and buyer is a virtual no-brainer. A useful analogy, one that can help you learn to argue your way back and forth between narrower and broader readings of a case, is to think about a parent dealing with an errant child. What lesson is the child supposed to learn when she is admonished for leaving a favorite toy on the living room floor? 1. The narrowest holding would focus on leaving that particular toy in the living room when dad is cranky. 2. A broader holding might mean no toys allowed in the living room. 3. A broader holding still would mean pick up after yourself. When the child leaves an article of clothing on the bathroom floor, it is easy to imagine the parent citing the earlier admonishment for Proposition #3 and the child responding, "But you said toys." Obviously, law professors did not invent this argumentative technique, finding the rationale in case language. We have assumed so far that you can easily discern the rationale for cases you have studied. This won't always be so. Sometimes the court will be cryptic, and you'll have to rely on class notes and discussions or on policy analysis of the sort we described in the previous chapter to decipher why the court ruled as it did. Sometimes, however, the court will be quite forthright about its rationale. The case Oy Johnson v. Davis, 480 So. 2D 625 FLA. 1985, for example, which imposes seller liability for non-disclosure, explains, one should not be able to stand behind the impervious shield of caveat emptor and take advantage of another's ignorance. The law appears to be working toward the conclusion that full disclosure of all material facts must be made whenever elementary fair conduct demands it. Students analyzing the visiting scholar example and relying on Johnson v. Davis were obviously rewarded for taking the court's own statement of rationale as evidence that the rule should be extended to cover the scholar's situation. They were rewarded even more if they also saw the other side and argued that fair conduct does not include imposing a burden on persons like the scholar, who are not parties to the buyer-seller transaction. Multiple rationales. The final pattern here precisely parallels the case of competing purposes we discussed in the previous chapter. Cases can often be interpreted as based on several rationales, and these may point in different directions and even conflict with each other. The rule requiring disclosure by sellers could stem from the court's desire to ensure that the party in the best position to have information about defects should be required to disclose. On this theory of unearthing information, requiring disclosure by the tenant as the party in possession would appear to be a logical outgrowth of the rule. But if the disclosure rule is justified on the grounds of encouraging trust between contracting parties, then extending disclosure requirements to the tenant appears unnecessary, although perhaps tenant should owe a disclosure duty to landlord. And if we place the seller disclosure rule in the broader context of caveat emptor, then we may affirmatively oppose the expansion of liability to tenants. Here we might say that we want buyers to be vigilant when inspecting property, and we permit lawsuits against sellers only because we frown so heavily on fraud. Unlike a deceptively silent seller, the silent tenant won't be taking the buyer's money. In the tenant's case, then, buyer vigilance may resurface as the court's principal concern. A word about technique. Applying vs. extending a case. We have been talking so far as if there are only two things you can do with a precedent: follow it or distinguish it. But following precedent can be somewhat more complicated than this analysis suggests. One way to follow precedent is simply to apply the earlier case to the present facts. Another way is to extend the earlier case to reach this one. The difference is subtle but important. Indeed, it is the sort of difference that can separate a B exam from an A. Recall one last time our visiting scholar hypothetical, and assume you have just finished crafting an argument that Johnson v. Davis, the case imposing liability for non-disclosure on sellers, should be distinguished. One way to argue the other side, that is, to argue that we should IOU Johnson, is to insist that the earlier case has already settled the matter at hand by holding that any party with a financial interest in the conveyance has an obligation to disclose known defects. Thus, your argument continues. The resolution of the visiting scholar case is simple and straightforward. Since the visiting scholar had a financial interest in the conveyance, and since he knew about the defects, Johnson applies, and the visiting scholar is accordingly liable for non-disclosure. Note, by the way, that we've relied on a broad holding of Johnson broad enough to impose liability beyond sellers to include others with a financial interest in the property. But assume instead that Johnson contains language specifically limiting the reach of the holding to sellers. E.g., seller offers a parade of horribles that it asserts will follow if we impose liability for non-disclosure in this case, predicting a slippery slope that will eventually lead to lawsuits against mortgage companies, tenants, and even the gardener and the young lad who cuts the lawn. But we need not decide today whether other parties with such varying degrees of financial interest in the transaction would be liable for non-disclosure. In those circumstances, an argument that Johnson applies to the visiting scholar is obviously a dog that just won't hunt. He's a tenant, not a seller, and the court expressly declined to decide his case in Johnson. But an argument that the earlier case should nevertheless be followed here is by no means foreclosed, for you are still free to contend that the rationale that moved the Johnson court should persuade the court here to confront the issue that Johnson avoided and extend the earlier case to cover the visiting scholar. Understanding the difference between applying and extending a precedent can thus help you to write exam answers that impress the grader in two ways. First, she'll be impressed by your careful reading of the precedent, and by your recognition of the fact that you weren't free simply to apply the precedent to the new facts. Second, she'll be impressed that this obstacle didn't prevent you from developing an argument for following the precedent by extending it rather than merely applying it. C. Dealing with multiple cases. Although we have now described many ways that exam questions can create doubt about case application, we have been purposely oversimplifying the matter. That's because so far we have unrealistically written as if there's only one case relevant to the problem you face on your exam. We suspect many of you noticed this in our discussion of human cloning. Sure, you mused, Casey could be read to suggest that reproductive freedom is the core of privacy protected by the Constitution. But what about the long-accepted practice of outlawing bigamy? See Reynolds v. United States, 98 U.S., 145 1-879. Doesn't this suggest that some types of reproductive activity may be limited? And what about Bowers v. Hardwick, 478 U.S., 186 1986? Doesn't that case, upholding Georgia's statute criminalizing sodomy, suggest that the Constitution protects only traditional practices? And won't this make it harder to fit human cloning under a Casey rationale? It sure does. The point here is that exam problems often ask you to evaluate scenarios for which a whole line of cases may be relevant. This is particularly true in constitutional law, though not because of anything intrinsic to that subject. There are famous lines of cases in other law school courses, e.g. the indefiniteness cases in contracts and the takings cases in property. And when you research a particular problem in the real world, you will almost invariably discover a complex grid of precedent. But given the recent trend toward teaching first-year common law subjects as reduced credit single-semester offerings, with the result that professors in those courses feel greater pressure to emphasize breadth of coverage over depth of analysis, you are unfortunately less likely these days to encounter extended lines of cases outside the constitutional law context. Certainly, if you were asked to answer a question about human cloning, it might make sense to consider the many cases decided under the privacy rubric that begins in the birth control case. Griswold v. Connecticut, 381 U.S., 479 1965. And when you consider a line of cases, each of them may provide a rule-rose trimester system and articulate a rationale, personal freedom. So when evaluating a line of cases, you may have conflicting rule formulations within a case or among cases, and you may have conflicting rationales within one case or among cases. The basic building blocks for writing your answers are the same as those described in the previous sections, so we need not multiply examples here. You just need to remember how many more possibilities for ambiguity are available to the professor for writing questions, and to you for crafting dazzling answers. Finally, on the subject of dealing with multiple cases, there will be some exam questions where you may not be deciding how to apply a line of cases to a new problem like cloning. Instead, the new problem may call upon you to decide which of two seemingly independent lines of cases applies. Consider, for example, U.S. Term Limits v. Thornton, 514 U.S. 779 1995, where the Supreme Court had to decide how to classify a rule barring long-time office holders from appearing on the ballot. Was it a ballot access measure under the line of cases granting broad leeway to government, or an additional qualification for public office under the line of cases limiting legislative authority? We'll describe the two lines of cases problem more fully in the Competing Domains section of Chapter 7.